Legal shorthand 100 words per minute. Ready? Judgment para. Since the issues of fact and law involved in all these writ petitions are identical, they are being decided together by this common judgment. Para. The petitioners have approached this court to challenge the judgment and order dated 30th November 2019 passed by the Cooperative Appellate Court. By the said order, the revision application filed by respondent numbers 1 to 6 was allowed. The appellate court set aside the order of the Cooperative Court which had rejected the respondent's application seeking dismissal of the dispute for want of jurisdiction. The appellate court held that the cooperative court had no jurisdiction to entertain certain prayers in the dispute. The relevant facts giving rise to these petitions are as follows. Respondent number 6 is a cooperative housing society registered under the Maharashtra Cooperative Societies Act 1960. It was initially classified as a tenant ownership society and was later converted into a tenant co-partnership society with effect from 19th March 1990. In 1997, an administrator was appointed for the society. Without conducting elections, the administrator issued a notice dated 30th September 2005 calling a general body meeting on 16th October 2005. One of the subjects of the agenda was the proposal to hand over the society's property to a developer for redevelopment. Thereafter, on 17th April 2006, the administrator executed a development agreement in favor of respondent number 1 developer for a consideration of rupees 11,74,000,000. The petitioners filed dispute number 36 of 2013 seeking a declaration that the resolution passed in the general body meeting dated 16th October 2005 was illegal and void. They also sought a declaration that the development agreement and the power of attorney executed in favor of respondent number 1 were null and void. The respondents contested the dispute by filing a written statement. After framing of issues, they filed an application seeking that issue number 10 bracket small a be treated as a preliminary issue. Accordingly, the cooperative court heard the question whether it had jurisdiction to try and decide the dispute as a preliminary issue. By order dated 11th January 2019, the cooperative court held that it had jurisdiction to entertain the dispute. Respondent number 1 to 5 thereafter filed a revision application number 37 of 2019 before the Cooperative Appellate Court. By judgment and order dated 30th November 2019, the Appellate Court allowed the revision. It held that the prayers bracket small a to small m and p to s were beyond the jurisdiction of the cooperative court and hence stood dismissed. However, it held that prayers bracket small n, bracket small o and small t were maintainable. Stop. Aggrieved by this, the petitioners have filed the present writ petition. Stop.